With your lordship's kind leave.
Sondi, government is midway, Mr. Sondi.
I'm just requesting that your lordship may kindly accommodate me till Monday, my lords, for just 20 minutes for my reply.
Monday we have already. Let us see, because today also we are working only up to 3:15, 3:20. There's a reference at 3:30. No?
Please.
3:45. 3:45. So somebody else may start today, Mr. Sondi.
Most certainly. Most certainly. I may just kindly be given 20 minutes on Monday as convenient to your lordship's board.
We'll not keep it on Monday because Monday we have another batch. We'll keep it on Wednesday.
Wednesday.
If it is not concluded today, we'll fix it on Wednesday.
Wednesday. So grateful.
Yes. Wednesday we have a lot of matters. Tuesday suits you.
Lord, Tuesday, may I kindly request for the first half, my lords, if your lordship's board permits. I'm in a parliament at 2 p.m. before the Honorable Supreme Court.
First half we can't. Then Thursday, Mr. Sondi.
In fact, my lords, may I take a chance on Wednesday, my lords? If your lordships could just give me 20 minutes before the other matter, I will.
Let it be on Wednesday. We'll see if time permits.
Please.
Being part-word, it will come on the top of it, on the list, yes. The final hearing list.
I'm so obliged, my lords.
Yes.
So obliged.
The second part of the arguments, my lord, that was under challenge is the GOMS number 96.
Yes, we will adjust it. Yes. Yes, please.
Yes, my lord. The second part of the challenge is GOMS number 96, my lord. They claim that the rule has been wrongly applied. That should have been vertical, horizontal, and their claim is not being made. Not much has been argued, my lord, except to say that it should have been applied so and so. How they are affected, they have not stated anywhere. And this is also an important, my lord. None of their pleadings reflect as to how the effect of applying either way has hindered from further selection process or not from being selected.
Yes.
But this Act of 1995, Act 1 of 1996, which is the Persons with Disability, has come in 1995-96. That was for the first time, rules have been amended in the erstwhile state of AP in 2004. That I am quoting these facts, my lord, for a reason. There is a delay also on part to show how the delay is challenge to rule also. 252 GO, my lord, by fixing 3 roster points in 2004. 6, 31 and 56. This was the first time, my lord, amendment was caused to the General Subordinate Service Rules. Wherein there was also a proviso which says that these will be carried forward for the next 3 succeeding years. This rule came to be challenged in an OA, the carry forward of 3 years in 2010.
Yes.
And in pursuance of directions, it was allowed, my lord, in pursuance of the directions of the tribunal, GMS number 23 was issued. That 3 years of carry forward was reduced to 2 years and interchangeability. Thereafter, in 2016, GO 196 was issued after bifurcation, my lord, adopting the General State and Subordinate Service Rules to the state of Telangana. Then Disabilities Act 2016 was enacted. And then, my lord, GMS number 10, which is in executive in nature, my lord, was issued, increasing 3% reservation for disabilities to 4%. This was in 2018. My lord, a 4th roster point also was brought about, my lord, because autism was included in the disabilities, 82. My lord, this in 2019, 22nd July 2019, wide GMS number 96, which is under challenge before your lordships, has been amended on 27th July 2019. That this is strictly in compliance with section 34 of the Act 2016. To only show how much closer we were to complying with the directions, my lord, your lordships may kindly be taken to the counter filed by the department, my lord, filed by respondent number 3. We have given a comparative table with section 34 as well as the rules framed by the state. Well, this is 26038. Yes. From the lead map. Counter is very small. That counter is filed by respondent number 3.
By Mr. TPPSC.
No, my lord.
No, this is by PSC written. This is by Mr. Raj.
It's a very small counter.
Yes.
By the Women and Child Welfare Department.
This is also not. It is in WP number
26038.
This is by petitioner, court officer.
They were filed on 8th November.
Yes.
But we have again, my lord, in para 9, 10, 11 and up to 14, my lord, 13, we have just narrated, my lord, how the rules came to be amended in the state. Para 14, my lord, your lordships may kindly be taken. But we have given an extract of section 34. 1 and 34 2 and then the rule, my lord, which is amended in the state now. Lord, in page 34, the bolded portions your lordships would see under section 34 and the bolded portions in the rule. Lord, we have simply extracted the words and the same provisions have been extracted into the rule in strict compliance of section 34 2. Lord, your lordships would see the page 8, my lord, internal page 8, section 34 1. The reservation, every appropriate government shall appoint in every government establishment not less than 4% of the total number of vacancies in the cadre strength in each group of posts meant to be filled with the persons with disabilities, of which 1% each shall be reserved for persons with benchmark disabilities under clauses A, B, C, and 1% for persons with benchmark disabilities D and E, namely. My lord, your lordships would see the bolded portions, my lord. That is how we have incorporated. Now, the roster points also were fixed, my lord, because the reason for fixing roster points, my lord, your lordships may kindly be taken to 34.2, next page itself, my lord, at internal page 10 on the top.
Yes.
Where in any recruitment year, any vacancy cannot be filled up due to non-availability of suitable persons with benchmark disability or for any other sufficient reason, such vacancy shall be carried forward in the succeeding recruitment year. And if in the succeeding recruitment year also, a suitable person with benchmark disability is not available, it may first be filled by interchange among 5 categories, like other benchmark disabilities, and only when there is no person with disability available for the post in the year, the employer shall fill up the vacancy by appointment of a person other than person with disability. Like what we did, if your lordships would see on internal page 11, Milord, sub rule 3, Milord, that Roman 3, we have just extracted 34.2 into the rule position.
Their objection, if we correctly remember, up twofold. Number one, that one category which you have shown as in vertical, it should have been horizontal or vice versa.
That is their argument.
That is one argument.
Yes.
Second argument was that this roster point is not applicable for a special reservation.
That is their argument. Yes.
Yes.
Now, my respectful submission is, my lord, when the section, the very act, Parent Act, Disabilities Act says, my lord, that each of these benchmark disabilities have to be notified, and if no person is available, they have to be carried forward. My lord, and then only for 2 succeeding recruitment years, and only if there is no person with that disability, then only it should be open to persons other than disabilities. Like they had to identify a point, a vacancy has to be identified for those benchmark disabilities in my respectful submission.
Yes.
It could not have been done by, my lord, without earmarking a vacancy, because it has to be carried forward. We have to verify if there is a person available. If he is not available, that vacancy has to go to next year as per this act.
Yes.
The act is not under challenge before your lordships today, my lord.
Yes.
It's only the rule.
Act doesn't talk about roster point. It only
No,
talks
it
about
says-
carry forward.
Yes, ma'am. It says the point has to be, like it has to be reserved for a benchmark disability, and such benchmark disability not available, then it should be carried forward to the next recruitment year, Lord, and so on. But after 2 years, my lord, it gets the color of a general it expires, my lord.
Yes.
Lord, only to fulfill that portion, my lord, to carry forward or to, my lord, to identify a vacancy for a particular benchmark disability, my lord, the roster points have been placed. If not otherwise, my lord, other way around, my lord, is very difficult, my lord. It is highly, it is to carry forward a vacancy, my lord, it has to be identified first. A vacancy has to be identified. The other way around, my lord, we couldn't see, because all these points, your lordships would see SC/ST reservations also, my lord, they have to be carried forward. A point has to be notified, only then it can be carried forward. When the Parent Act is saying that such benchmark disabilities have to be reserved for these particular persons and have to be carried forward,
Yes.
they had to be, my lord, points had to be notified. My lord, without which, my lord, we cannot. Now today's day, my lord, there is, even if assuming there is 3 persons, my lord, from disabilities, out of this all entire vacancies, my lord, 3 persons come. My lord, 3 into 50 were called. My lord, they were not 50, all of them will not be there. Assuming, my lord, even these 3 vacancies are not filled up today, they have to be carried forward to next year for want of persons. They can't be opened up for general. Because these are all, my lord, these are not coming with communal roster points. These have to be overall horizontal, overall reservation, because it has to be 1% of the 100. Lord, it's not as in every, like women reservation, my lord, it can't be given 1% or 33% in every communal wise. Lord, once a person is appointed against this roster, he may be adjusted against SC, ST, OC. That's how it is working, my lord. As of now, that is the only way we are following since 2004. And that is how we have been doing all through all the recruitments. And we have strictly, my lord, complied with the rule has been framed strictly in compliance with the section. Now, my lord, your lordships may also see, my lord, this rule position has been notified in the first notification in 2022.
Which one is that?
The first notification, my lord, which was challenged and which was set aside, my lord, notification, my lord, 4 of 22.
26/4/22.
Yes, ma'am.
This
So it
was
is-
subject matter of challenge before single bench.
Yes, I'm only saying, my lord, the roster point system that we are following in disabilities,
No, this 26/4/22 was cancelled,
this was cancelled.
and cancellation order was under challenge.
Yes, no, my lord. 26/4/2022, what happened, my lord? They have issued. This was cancelled subsequently. Yes, my lord.
That cancellation order was under notification
Yes.
was under challenge before learned single judge.
Yes, my lord. Yes.
Yes.
That was also affirmed. Lord, what I'm trying to place before your lordships is the disabilities rule, which has been enforced since 2004 and amended in 19.
Yes.
My lord, was also applied in 26/4/2022 notification, for which most of the petitioners applied. They have participated. They have not raised this objection or challenge to rule at that point of time. notification got cancelled for various other reasons, but this was available for them even at that point.
Another ancillary question.
Yes.
This reservation aspect, it was there in Geo 55 also. Suppose this 29 was not issued
Yes, ma'am.
and your selection would have continued as per Geo 55 itself.
Yes,
So
ma'am.
whether you would have continued with the similar kind of reservation?
It could have been communal, it could have been as per the communal roster points, 50 into each community, vacancy into community. That is what was held to be bad in Jafar Sahib. That is what was incorporated in 55. To clarify, we felt, when it said rule of reservation, there was some ambiguity, that's for that reason we had to bring 29. It was merely to clarify, rather than to say it was, because 55 was never given effect to. 55 was brought in 22. Notification was brought in 22. Both the notification as well as GO, both notification got set aside and cancelled. GO got modified. It was never given effect to see the consequences.
Yes.
GO 55 that's. But the procedure which we are following today in 29 is a procedure which has been existent since 1967 and which has been approved by the High Court and the Supreme Court.
Yes.
But my respectful submission is, 26/7/2019 the GO has come. It was also notified in the notification in 2022. None of them have placed challenge. And the same was again notified, again in the second notification also after cancellation on 19/2/2024. It was again notified in 19/2/2024. It was notified, They all participated. Even
this 19/2/24 was also subject matter of challenge before single bench?
Yes.
Yes.
That was also subject matter before the single bench. It
So
was
this 19/2/24 is a notification which is issued in furtherance of 29, Geo 29.
yes,
Right. The
Yes,
only one deviation somewhere they were showing that it is not there in Geo 29, which is there in
55.
GOMS in the notification.
yes, ma'am. But 29 was placed in the notification. 29 immediately on 29 was issued on 8/2. Notification was issued on 19/2. So far as that's where I was trying to separate these two. 29 is a issue with respect to shortlisting of candidates. 96 is with respect to reservation for disabilities.
Yes.
What the reason I am referring to these two dates, the second notification is issued on 19/2/2024.
Yes.
They had the opportunity to challenge the notification at the first point of time. Had they been agreed by the rule or
That has already been argued by Learned Counsel for TPSC that it was
29.
challenged on the ground of delay. Learned Single Judge has not considered affirmed by,
So
by
far as
the
yes, I'm also on the rule, even the rule. They don't specifically plead anywhere anything except only to say that the rule is badly applied, or the disabilities rule. What they say is it should have been vertical, horizontal. The vacancies were notified at the very beginning along with the notification. What are the number of vacancies reserved for disabilities? This was as per the roster points which are already there. So they had the first information on 19/2/24 itself that certain posts were specifically identified and notified for disabilities along with the notification itself. And I have, along with the brief note, I just gave the dates, After the notification, there's a lot of process, Your Lordship. Preliminary examination was conducted. Preliminary key was published in June, 13 June, then 17 June. Objections were invited. OMR sheets were made available on 24th June. And the final key was published on 7th July. Then, list of shortlisting candidates